are relating to social. So social media అంటే social media రెగ్యులేట్ చేయడానికి ఎలా ఉంది? ఐడియా దేశంతా ఐడియా యాక్ట్ కింద కొత్త రూల్స్ క్రియేట్ చేశారు. కొత్తగా అంటే ఈ సోషల్ మీడియా కొన్ని రూల్స్ క్రియేట్ చేశారు. ఐడియా యాక్ట్ 2021లో వచ్చి యాక్ట్ వచ్చి 2002లో మనకి ఐడియా యాక్ట్ వచ్చింది. కానీ రూల్స్ వచ్చి 2021లో సోషల్ మీడియాకి సంబంధించి.
Digital personal data protection bill 2020.
పెట్టేది పోస్ట్ పాస్ అవుట్ బిల్ పోస్ట్ అవుట్. కానీ ఇంకోటి పెట్టాడు మా అనుకున్న వ్యక్తులు కోడ్ అని అక్కడ పెట్టాడు.
రూల్స్ 2021
రూల్స్
Information technology intervention guidelines and digital media ethics code regulation 2021.
అవి ప్రజెంట్ పోస్ట్
నేను చిన్న ఇన్సిడెంట్ జరిగింది. ఫోన్ వచ్చింది. అయితే కస్టమర్ నుంచి ఫోన్ చేశాను. ఏదో అర్జెంట్ ఇన్ఫర్మేషన్ ఉంటే 9 వస్తున్నాను. నేను 2 days వరకు ఏమెయిల్స్ చేశాను. 30 ఏమెయిల్స్ చేశాను. 40 ఏమెయిల్స్ చేశాను. 9 అంటే వాడు ఫోన్ చేశాడు. మీ పేరు మీద MDMA అది డ్రగ్స్ ఇవన్నీ వచ్చింది. మేము సీరియస్ ఎడ్యుకేషన్స్ ఉంది. అది ఫోన్ అంటే పోలీసు వాళ్ళకి రీచ్ అవ్వాలని అనుకుంటున్నాను. అంటే వాళ్ళ డీటెయిల్స్ అడగడం కొంచెం మరి అది ముందు భయపెడుతున్నాడు. వాళ్ళు అని చెప్పి అది చెప్పారు. మీకు త్వరగా వస్తాను. మన సైబర్ క్రైమ్ మన విజయవాడ ఎక్కడికి
ఉంది. మన కమిషనర్ ఆఫ్ పోలీస్ ఉన్నాడు కదా, దాని దగ్గరలో సిపిఆర్ స్టేషన్ సైబర్ క్రైమ్ పోలీస్ స్టేషన్ అక్కడికి వెళ్ళి అఫీషియల్ రిపోర్ట్ చేయవచ్చు. మీరు చెప్పాలి కదా చెప్పు.
Good morning to all. Today I am going to discuss the topic on social media. Well, we will see what is the social media. Social, we have to divide the term into two parts. One is the social and one is the media. Social is what we are doing in the society. Social plus media. Socialness is based on society, what we have to express our feelings. Express our feelings. We can express our feelings like anything. We can create anything. We can share anything. We can discuss anything. We can transfer anything. That is what social and what we are doing is in society. Society is we are having relatives, friends, and we can make friends. We can make relatives. Those are all in our society. So here, media is entirely different from this one. Media, what we know up to our knowledge is, media is a platform for transmission of these messages. Whatever we want to convey to others, we can transfer through a platform. You should have a platform. Without a platform, there is no media. So what are these platforms? One is you should have a internet. Internet connection is there. Internet connection is a must. And the second one, you should have a application to process your feelings. Application like you can call them as apps. Apps or applications. So by using this, we are communicating with the society by using this media. Now we have what we have called is so one more term also we have to know is intermediaries. Intermediaries is equal to media. Intermediaries. Intermediation are another term for media, like Facebook, WhatsApp, Instagram, Twitter, YouTube, and we also include vloggers, bloggers, and so on. This list goes. These are all the intermediaries in our social media discussion. So, if we take the Act of Information Technology Act, we call it as short for IT Act. IT Act 2000. So, in this act, there is nowhere there is a word called social media. There is no social media anywhere. So, no definition for social media. There is no definition for social media. So then how you are going to recognize the social media? We have to recognize the social media. Why we have to recognize the social media? Because there are a lot of offences and crimes committed by using this social media. Like you can call them hacking, skimming. Skimming is equal to morphing of someone photos in this uploading. Obscene photos or news or something like that. Obscene material. We call it obscene material. Next is harassment. These are all what are the things are going to happen through a social media. So you do harassment, threatening, or imitating. Next is defamation. These are all the crimes which happen with the social media. So, what is the law that is regulating the social media is mostly it is only the Information Technology Act 2000, which also combines with the IPC. IT Act plus IPC gives the sections what they require for crimes. So I'll just write down the IPC sections. 124 A, 153 A, 499, 505, 506, 509 and 295A. These are the IPC sections which we can combine with IT Act. So here what we are doing is we are combining these IT Act sections and IPC sections. So what are the IT Act sections? The most important thing is section 66A. under this set, what the we have to go through your phones or I didn't write that full, it's a big paragraph.
But anyone will structure the
Yes, we have to learn why you have to use structure. So what happens is, this is the landmark case, Shriga Singhal.
Shreya Singhal. Shreya Singhal కదా.
SHREY.
RG నా.
correct.
Shreya Singhal. Shreya Singhal versus
Union
of India.
In this case, what happens is, a lady on her Facebook post the death of some political leader is after death of a political leader, we have to shut down all the shops and establishments. And what happens is, what she posted is shared by her friend. So this, what the government does is, the government of Maharashtra, they file a case on mainly on section 66, basing on section 66A and 69A. So what is the main here is this 66A. We have to look into the constitution of Article 19A. Why we have to look into the constitution of Article 19A is Article 19A. 19A1.
19A. 19A.
Small a.
Small.
Subclass A. Right to, we have a right to freedom of
Expression.
speech and expression.
Speech and expression.
What she contested it is violating my fundamental right under Article 19(1)(a). So the government don't want me to execute my right. So what the Supreme Court gave the judgment is, yes, you have the right to freedom of speech and expression, but the other, that 69A is valid. This is what the 69A suggests, that the government can take some reasonable restrictions and it can curb you, it can stop you from transmitting some information. This, the Supreme Court struck down this section 66.
What's said by section 66A of the ITA?
That's how the one.
ఆ ప్రొవిజన్ పెద్దదిగా ఉందా అంటే అసలు సెక్షన్ 66A ఏం చెప్తుంది? వాట్ సెట్ బై సెక్షన్ 66A హౌ ద కాన్స్టిట్యూషనల్ ప్రొవిజన్స్ ఆర్ వైలేటెడ్. ఎట్లా వైలేట్ చేస్తుంది?
66A of Act criminalizes the sending of offensive messages to a computer or other communicating medium. Anybody sending an offensive messages, he is criminalized.
Offensive messages may forward from one person to another person.
Offensive messages should be a threatening message.
That is again the definition. How the government perceives it offensive message.
Where Act what said by section 66A exact wording are used in the IT Act.
Punishment for sending offensive messages to communication service, etc. Any person who sends by means of computer resource or communication device any information that is grossly offensive or has menacing character, or B, any information which he knows to be false but for the purpose of causing annoyance, inconvenience, danger, obstruction, insult, injury, criminal intimidation, enmity, hatred or ill will persistently by making use of such computer resource or a communication device. Subclass C. any electronic mail or electronic mail message for the purpose of causing annoyance or inconvenience or to devise or to mislead the addressee or recipient about the origin of such messages shall be punishable with imprisonment for a term which may extend to 3 years and with fine. Explanation for the purpose of this section terms, electronic mail. An electronic mail message means a message or information created or transmitted or received on a computer system, computer resource or communication device, including attachment in text, image, audio, video and any other electronic record which may be transmitted with the message.
Not section 66A, what it says. Whatever you do, it's wrong. It is punishable. Implementation not apply.
Anything that any complaint.
Class A, what it is saying is subsection class A. Any information that is grossly offensive, menacing character only that one. That means it is first one. Second one they say you should be able to hatred, will, abstraction, insulting, injury, intimidation. There only it is there. Otherwise it is not there. But that should have one format. It is you are knowing that one will impact other person, but still you are sending.
But this message doesn't have so impact. What the Supreme Court decided is impact is immediate impact. It should have immediate impact, not a long time impact. So the message has no impact on society. So that is violating the right to freedom of speech and expression. So the Supreme Court struck down the 66.
So why section 66A was struck down by the apex court is, what you said, article 19(1)(a) clearly says right to freedom of speech and expression. If you forward the information from one person to another person, you can express. Whether the expression is, you can feel something, you can feel an injury, you can feel as a damage, whatever may. So freedom to express, freedom to speech, freedom to speech or express means to translate the information from one person to another person is not an offense at all.
Yes, sir. Other way of looking at it is
the other offenses are there.
Whatever they are prescribed, they are punishable in IPC anyway.
They can punish it.
But the only thing is you can't.
Exactly. If it is a defamatory matter, you may proceed for defamation. You may proceed with the Indian Penal Code. So you got, each and every citizen has got right to speech and right to express. Where, for example, I received some information from one person. The same may be forwarded to another person. Same may be forwarded to some person is not an offense at all. Whether the material is offensive material or is injury to the health or injury to the property or whatever may be, that forwarding is not an offense at all. అంటే నా మనసులో ఏది ఉందో అది మీకు నేను ఎక్స్ప్రెస్ చేసినంత మాత్రాన, మీకు తెలియపరిచినంత మాత్రాన అఫెన్స్గా ట్రీట్ చేయాలి అంటున్నాను సెక్షన్ 68 అదే.
So after this judgment, the government took some steps to frame rules, but not act. It started to frame rules under
IT Act.
Rules under section 69 and 69A.
A new rule was introduced under section 69A by virtue of the IT Act Amendment Act.
First amendment was in the year
One second, I have that provision. 69A.
Otherwise, block public access to any information for the cause of national security and public order.
అంతేగా నేషనల్ ఇంట్రెస్ట్ పర్సన్ ని ఇంజూర్ చేసే
Public order అయితే you can stop it. 2008.
that is subject to some exceptions. There are some exceptions. But even Article 19(1)(a) is not absolute right. Subject to some reasonable restrictions may be imposed by the legislature. basing on public health, public interest, national security. For these grounds, the reasonable grounds may be imposed by the legislature.
You see what are the other acts or rules which have been passed. In the year they amended IT Act in 2008. Next one is IT intermediaries.
Intermediaries.
Guidelines. Guidelines. Rules.
These are the rules of it.
2000.
Now these are the rules are is in existence. Now in existence. 2011. So say a single case was passed with apex court in which year?
2015.
2015. So prior to 2015, these are the rules are available. Now consider. So judgment was passed in the year 2015. So these are the rules are came into force in the year 2011. So that means these rules are is in existence.
Reasonable security practices and procedures. And sensitive personal data or information.
Rules.
So shortly called SVDS rules 2011.
SVDA. Sensitive personal data information. SVDA.
The last rule is the IT intermediaries.
Intermediary
Guidelines and digital media ethics code rules in the year 2021.
the latest.
For the first time the government had said what is a social media. They didn't clearly said what is a social media, but somehow they included the term social media.
The social media, for the first time, the government of India discussed in the IT, the information technology, intermediary guidelines and digital media ethics code rules 2021.
As we have first discussed, who are the intermediaries are the media. Here what the government is doing is regulating the media,
only
not the
social
service provider. Service provider don't have anything to access on the internet. He can't go through see through the table or something. But whatever is happening, these intermediaries can observe, modify, alter. They can do whatever they want. So government imposed some restrictions on these platforms. Platforms is like WhatsApp, Facebook and these things. So first time they have given, you have to give the personal data of the user to us whenever we require. The government can take your personal data whenever it requires from the intermediaries. If you don't comply to that thing, you have to pay fine. Then something like that, and those are all the punishment they have. So here what we have to understand is the government has the upper hand in accessing everyone's data. Again, what the government is doing here is with social media and plus OTT platforms, movies, and it has given some age restrictions like under 13, 14, or 16, adult, and universal. It has given some classifications like that.
Until 2021.
Cinema photographer.
Yeah, yes, all in this.
And the additional provisions in the rules is that first, the platform needs to have an officer of Indian origin, and that whenever the government asks for information, they need to reply within 24 hours. So the rules do not prohibit Facebook, it could not comply, and they thought we are going to stop Facebook in India.
ఇప్పుడు మనం ఒక ఇంకోటి తెలుసుకోవాల్సిన విషయం, అండర్ వాట్ ప్రొవిజన్ ఐటీ యాక్ట్ దీస్ ఆర్ ద రూల్స్ ఆర్ ఫ్రేమ్డ్ బై ది లెజిస్లేచర్. అండర్ వాట్ ప్రొవిజన్ దీస్ ఆర్ ద రూల్స్ ఆర్ ఫ్రేమ్డ్ బై ది లెజిస్లేచర్. ఫైండ్ అవుట్ చేయాలి. What is the sanctity? What is the legal sanctity of these rules are passed by the which authority? పెట్టుకుంటారు అట్లా అట్లా కాదు. యాక్ట్ సమ్ ఆఫ్ ది పవర్స్ ఆర్ డెలిగేటెడ్ టు ది అప్రాప్రియేట్ గవర్నమెంట్. సమ్ పవర్స్ ఆర్ డెలిగేటెడ్. The delegated power subject to some limitations. Whether this guidelines passed by the appropriate government within those guidelines or exceeding the guidelines, you may find out. Now, what is the constitutional validity of these guidelines or framed by the apex body? There is some. There is a parent act. There is a original act is the parent act. What is the original act? Information Technology Act 2000 is the parent act. This parent act, some of the powers delegated to the government for framing of the rules and regulations. What are the powers are delegated to the executive? Those executive can frame these rules. Whether those powers at the time of delegation, there are some boundaries for framing of the rules. Whether those rules framed by the authority within those boundaries are exceeding the boundary, you may find out. Then you can challenge even rule 2021 rules. You can challenge these rules are violate the constitution provision article 19(1)(a). You can challenge subject to constitutional validity. Whether these rules are first one legally sanctioned or not, whether legally constitutionally valid or not, you may challenge the court of. For that purpose, whether that is the main act, that is principal act. The principal act, it gives permission to the appropriate government for framing of the rules. You may find it.
By this rule, government can know who is the starter of a message, then who is the first sender of the message. Because of these intermediaries complying to the government, they can know who is the starter of the first message. Like that, those are the set rules numbers framed in this rules. And again, these OTT platforms are also controlled and by this rules only. So age restriction is given and some vulgarity is removed. If you find anything vulgar or obscene in these things, you can complain to the officer. The officer also has been given in those rules. So, at last I conclude my discussion. So, social media is a good and a bus. Here good is wow.
Yes, correct.
Wow is a sad. What we can use it either a good way or we can use it in a bad way. Anyway we can use. Thank you, sir.
Next, Again,